Good morning. Are you Trinity Hughes? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Hughes, in
Right from the start, this follows a familiar rhythm of a courtroom, but don't be fooled by the calm. What's happening here matters deeply. This is the moment when rights are quietly surrendered, often in less than a minute. No jury, no trial, just a life-altering decision buried in legal language. And the real question is this: does a defendant truly understand what comes next?
Number 25, DCCR 0770, you're charged with the state jail felony offense of unauthorized use of a vehicle from May 8th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement is for a 5-year deferred probation, $500 fine, and you will be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
This is where the law turns serious. That immigration warning isn't a formality, it's mandatory. A single guilty plea can echo far beyond this courtroom. Deportation, denial of citizenship, permanent consequences. The judge is making sure the plea is knowing and voluntary, because once this moment passes, there's no rewinding the tape.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Hughes is not competent?
No, Your Honor.
And any history?
There's some slight history of in Orange County, some cases that were refused, Your Honor, but no convictions or anything like that. So I would ask that we go forward to that.
Okay. So, Ms. Hughes, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. I'm going to waive the pre-sentence report and to find sufficient evidence to find you guilty and follow your agreement and defer all proceedings for a period of 5 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, then this is a great opportunity because you don't have a felony conviction on your record. And at the end of the probation period, the case will actually be dismissed. You'll never...
Listen closely. This is the golden ticket of criminal court. Deferred adjudication. No conviction, no felony record. If probation is completed perfectly, miss a single condition, and the deal flips instantly from second chance to prison time. It's not freedom, it's conditional mercy. And in this system, mercy always comes with strings attached.
Have a conviction. The other side of that is if you violate any condition of probation, you could be brought back into court, you could be found guilty of the offense, so you'd be a convicted felon, and you could go to the state jail prison for up to 2 years. Do you understand? Also, it's important for you to know that if you get on probation, do everything you're supposed to, pay your fees, fines, show up, do everything. I sign early terminations for probation all the time. So if you do it all correctly up front, then you likely won't even have to do the whole 5 years, but that'll be up to you. You understand? So the first thing you'll do, you'll get some paperwork today before you leave. As soon as you are released from custody, you need to make sure you go to probation and get everything taken care of. Okay, good luck to you, ma'am. Perry Robertson, 2 cases.
Sheets. Tracy has emailed you or sent the discovery sheet on where they are.
One defendant hears relief, probation, no conviction. Another hears prison time. Same courtroom. Same. And here's the brutal truth of the justice system. Same courtroom, same judge, but wildly different outcomes. One defendant walks out with hope. The next is staring down a cell door. This is where criminal history matters more than promises. Your past doesn't whisper in court. It shouts. Judge, one decision changes everything.
Morning, Mr. Hoffpower. I don't know if have I seen you up here yet? All right, so we're going on.
Kim, is a third degree.
Okay, so more of it. All right, so are you Perry Robertson?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
Your Honor.
Mr. Robertson, in cause number 25 DCCR 0498, you're charged with the state jail felony offense of evading arrest or detention with previous convictions, and that's from March 23rd of 2025. The indictment alleges you were previously convicted of evading detention February 23rd of 1998, and then again January 10th of 2000. And then it further alleges you were convicted previously of possession of a controlled substance, a state jail felony, April 22nd of 1999. Then after that was final, you were convicted of delivery of a controlled substance, a state jail felony, November 20th of 2000. And then after that, possession of a controlled substance, a state jail felony, November 4th of 2003. And then convicted of two delivery of controlled substance, state jail felonies, June 13th of 2005. After that, convicted of possession of a controlled substance, a state jail felony, February 19th of 2008. Again, convicted of possession of a controlled substance, a state jail felony, April 12th of 2010. And unauthorized use of a motor vehicle, January 7th of 2010. And then finally, possession of a controlled substance, a state jail felony, July 29th of 2024. And how do you plead to that charge? Are all of those prior convictions true? Did you enter your plea of guilty and true to all of those convictions freely and voluntarily?
Yes.
And because they're all actually true?
Yes.
All right, I do want to know, what was that what did he get last year? Possession of a controlled substance, July 29th, 2024. Cause number 24, DCCR 0025.
State jail.
State jail. State jail.
State jail time?
Yes, state jail.
Okay. You ever been to TDC on any of these cases? Okay. So you understand if I follow that agreement, you're waiving your right to appeal, right?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Robertson is not competent?
No, Your Honor.
And the agreement is for a dismissal in 0499, correct?
No, there's two cases.
Two cases, Judge.
What did I just read?
CC.
Oh, to run CC. Sorry. Let me go through. So then, that helps me. Hold on. I got to write this. All right, in clause number 25, DCCR 0499, you're charged with, give me a second, the state jail felony offense of burglary of a building from March 7th of 2025. This indictment alleges all of those same prior convictions that I read out previously. And how do you plead to this charge? And again, are all of those prior convictions true? And are you entering your plea of guilty and true in this case freely and voluntarily? State tenders number one in that case as
No
well.
objection.
It's admitted. Any evidence that Mr. Robertson's not competent?
No, Your Honor.
All right, so I'm going to find in each of your cases that you entered your pleas of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. And cause number 25 5 DCCR 0498 finds you guilty of the state jail felony offense of evading arrest or detention with previous convictions. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25 DCCR 0499, also find that you entered your plea of guilty freely and voluntarily and those pleas of true. Find sufficient evidence to find you guilty, and at this time find you guilty. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you in each of those cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. They will run concurrently, which means together.
This is a final stamp. 5 years. 2 cases running together, but still 5 years behind bars. And notice how the judge closes with firearm restrictions. That's not casual advice. It's a legal landmine. One mistake after release, one bad decision, and the system snaps back fast. This isn't just sentencing. It's the long shadow of a criminal record.
At the same time, I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right? Good luck to you, sir. Go back with Taylor.